Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments and I will answer your questions. Let me formally introduce myself. I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients who get status and their green cards in the United States. And tonight, as always, I am here to take your questions. That is my main priority. So go ahead and put your questions in the comments now. Just get comfortable with putting your questions in. It does not have to be, it just has to be anything that's immigration related, and I will answer your questions. I usually come with a topic to talk about, and so tonight I am going to talk about the Affidavit of Support. I get questions often. Now the Affidavit of Support is a part of the process, the immigration process. When a relative is petitioning for another relative, they do have to show that they meet the income requirements to be able to support their immigrant relative. So how long does an application for citizenship take? So Amanda, with my cases right now, I am seeing a processing time from 2 months to 6 months. So I know I've heard on live some people are waiting for a year. So keep in mind that what my clients are seeing in regards to processing times is not necessarily going to be the case for everyone. That's not guaranteed. However, I am noticing that especially my newer applications are going much faster at about 2 months, the processing time. I've seen the shortest is 2 months from the application submission to the actual swearing in. One of my clients just recently, a few weeks ago, received their citizenship on the same day as the interview. So I am seeing where they are trying, USCIS offices are trying to push through US citizenship applications. And if you really would like to get started on your citizenship application and get it filed quickly, you can definitely contact my office, schedule a consultation first. Let's go through your eligibility criteria, make sure you qualify, and then get started on filing. So keep your questions coming. I'm here to answer your U.S. immigration related questions. So put those questions in the comments right now. So now I am going to be talking about the Affidavit of Support. That is the process of applying for, so the process of showing that you meet the income requirements to be able to support your immigrant relative. Hi there, 49 Drake. It's so nice to see you as usual. So if I apply for citizenship from my country, it can be as little as 6 months through your service. So now, Joey Sugdale, I am not guaranteeing any particular processing times. And no attorney can guarantee processing times. So I am not saying that. However, what I am telling you is that I am noticing that my cases are seeing a processing time of 2 to 6 months. However, there may be cases where I may have clients and those cases may be longer. It really depends on the individual circumstances and from case to case, what is going on, the USCIS office, how backlogged they are, what are the conditions, the policies in the USCIS. So I'm not saying that I can guarantee certain processing times, but I am saying that right now I'm seeing a processing time of 2 to 6 months. However, that's not a guarantee that that will happen in your case. So keep those questions coming. I'm here to answer your questions, and so far I am liking these questions. So now the Affidavit of Support. So I get the question often, what if my relative does not work? If they are unemployed, does that mean that they can't sponsor me? And the good news is no, that does not mean that they have to put a hold on sponsoring you until they have an income. Because there are ways to still provide provide documentation, get a co-sponsor to provide documentation that even though your U.S. relative does not meet income requirements, someone else can step in to show that they meet those income requirements and still allow you to go through the process. So that is the point that I want to make with the Affidavit of Support. So what is the Affidavit of Support? I just want to break that down for you as well, because that goes to the root of that question, whether you can apply for an immigrant relative if you're working or if you're on disability. So I'm on business and want to move it to the U.S. So Joey Sukdeo, it's really going to depend on which country you're a part of. So there are investor type, there's an treaty investor visa called the E2. If you are the citizen of an E2 country, that is one way that you are able to expand your business to the U.S. And while you're running your business in the United States, you can live here, and so can your family. So my son is 20. My sis wants to sponsor him. If the process starts now, will it go through? No. So Joey, aunts cannot sponsor their nephews. So in this case, that definitely would not work. Your sister would have to apply for you, and then your 20-year-old son would have to be included as a child on the application. But here's the issue. If your sister applied right now for you, there's a processing time of about 14 years. And so what that means is that your son would definitely age out before the application can even be approved. And so at this point, just based on the facts that you're giving me, your son would not be able to pursue permanent residence through your sister. If my father is filing for me and I'm already in the U.S., can I stay until the filing is finished over 21? So Joey, yes, that is an E2 treaty country. So if you are interested in expanding your business to the United States, you can definitely give the office a call and schedule a consultation, because whether you qualify is going to be dependent on the nature of your business, how much of a substantial investment can you show, and other factors. So definitely give me a call, schedule a consult. If my father is filing for me, so if you're over 21, you're already here and you overstayed, you may be at the point where you will have to fix your status in the United States. And here's why. If you're in the United States and you're not the immediate relative of a U.S. citizen, then you likely will not qualify to stay in the United States and apply for the permanent residence. That's called adjustment of status. So if you are over 21, you definitely would not fall within the category that is qualified to apply for adjustment of status. However, there may be a way to fix your status. If you can show, so in this case, you do have a father who is, I'm thinking either a U.S. citizen or a permanent resident. If you're unmarried and your father's a permanent resident, it is a 5 to 6 year process. But if it's at the point where you have already overstayed by 180 days, then you are going to be inadmissible if you leave the country at this point. So leaving the country to try to fix your situation isn't going to offer a solution, because you will be subject to a 3-year bar or a 10-year bar. If you overstay over 180 days, that's a 3-year bar. If you've overstayed over 1 year, that turns into a 10-year bar, that you can't get a green card, can't get into the U.S., no visa to come back to the U.S. At that point, though, this is where there's this option to fix your status through the waiver. It's called the Provisional Unlawful Presence Waiver. And if the overstay or unlawful presence is the only basis for the only immigration violation you have, then you can stay in the U.S. Your father files for you. You then, once it is approved, you have to file this waiver with the attached approved petition. If it's approved, then you can wait until your interview, and as soon as your interview is scheduled, you can fly with your approved waiver and go to the interview, and at that point you would not have a bar that would be applicable to you. You can fly down just for the interview, finish the interview, and within 2 to 3 weeks, once you get your immigrant visa stamped in your passport, you would be able to come back. And so the whole process of you being outside of the country could be anywhere from 2 weeks to 6 weeks, where you would have to be outside of the US, just straightening out the situation. Now, keep in mind that this waiver, though, the next thing is, do you qualify for this waiver? Because there are specific requirements for it. So one is, do you have a U.S. citizen or legal permanent resident, spouse, or parent? You do, because you have your father. Now, will your father experience extreme hardship if you don't get the permanent residence? That is the question that definitely can put a hold on going forward in this process. Just because extreme hardship doesn't mean that your father is going to write a one-liner saying, I'm going to really miss my daughter if she doesn't get the green card, or I really hope my daughter gets a green card. Extreme hardship means that your father has to be dependent on you in some way, to the point that if you don't get the permanent residence, he's going to suffer some kind of devastating consequences in his own life. So, for example, in the parent-child relationship, it may be maybe a psychological impact. If your father is very close to you and is very dependent on you to help him from day to day, that may be an extreme hardship. It may also apply to a situation where you are the caretaker of your father, and if you should leave him, he could face devastating health consequences. He may not have a caretaker. He may need you to manage his affairs. And in a case like that, that could also be extreme hardship. If your father has to move with you to your country because he's so dependent on you that he needs your help and he needs to be with you, then that could be considered an extreme hardship. If your father is going to go to your home country and then face persecution, he's going to be a victim of crime, he's going to face language barriers, he's going to face lack of health care if he needs health care, lack of employment prospects. So these are also examples of extreme hardships, and those keep in mind that those examples are just examples. Extreme hardships can definitely range from case to case. That's where it's very important to schedule a consultation and talk through your particular circumstances to determine whether you could qualify for this. So applied for U visa, but what is your opinion and best ways to go and visit my parents and come back? So if you applied for the U visa, it's really going to depend on what point of the process you are at in regards to the U visa. I can't specifically give you advice because the information here I'm giving you is general information, and I don't give personal legal advice or personal legal opinions through here. However, there are ways to get advanced parole, to get work authorization through the U visa. Right now, they have also issued policy updates determining that you could apply for additional benefits once you have shown that you have properly filed your application and you pass the background check. Now, as for your ability to apply for advanced parole to be able to visit your parents, and it depends on, it sounds like you're in the United States. So keep in mind that when you're in the United States and you're applying for the U visa, it's not really considered a visa. That's just the colloquial way of referring to it. However, when you're in the United States, it's considered U status. So the U status, meaning you are, once you're granted the the status, you're going to be granted that to stay in the US. However, it's not having status does not necessarily mean that it's going to give you the ability to travel back and forth freely. The U visa, had you gotten it at the embassy in your home country, would have allowed you to move back and forth because it functions more like a visa, a multiple entry visa. However, the youth status is just grants you the ability to stay in the United States. So you would definitely have to seek advanced parole to be able to visit your parents, and especially in cases where you do have a good justification to see your parents. How long does the adjustment of status take? So it depends on what type of adjustment of status. Now, keep in mind that the E2 it's not a permanent. It doesn't grant permanent abilities to stay in the U.S. and it doesn't grant green card. It is a temporary visa, and you still have to show that you have temporary intent. Now, when it comes to adjustment of status, when you're applying for the green card while staying in the U.S., it's going to depend on whether you're doing it through employment, whether you're doing it through asylum, whether you're doing it through as a T or U visa applicant or beneficiary, whether you're doing it as an immediate relative of a U.S. citizen. So that's really going to depend. Since my mother-in-law passed away, has the sponsor, is there any certain stage for the app to be approved? So usually if she passed away before the application was approved, then it's dead in the water. However, if you were far into the process and your I-130 was approved, there may be the ability to pursue humanitarian reinstatement, but keep in mind that that is a discretionary form of relief for individuals in that situation. Do you think I should get the COVID vaccination before my medical exam for my K1 visa? So Stacy Boo, while I can't advise you directly or personally on what you need to do, many individuals are getting the COVID vaccination right now just because it is important to protect yourselves. And so if you did get the COVID vaccination before the medical exam, then it could very well, you would just pass the medical exam and that you would pass that criteria that requires you to have that COVID vaccination. Keep in mind that the COVID vaccinations are now going to be required starting October 1st, so on or after October 1st. Do you have to pay for a returning visa? From Trinidad to NYC, COVID happened, so borders were closed. So it's going to depend on your circumstances, Sweetness. If you overstayed in Trinidad, you're on a green card and you overstayed over 1 year, then you're definitely going to have to look at applying for the SB1 returning resident visa. However, whether you're going to have to apply for sure is really going to depend on the facts of your situation. What steps should I take if I overstayed my visa without applying for extension because I gave birth? So that's going to be more on the complex side. It's going to depend on how long you've overstayed. If you've overstayed over 180 days, then you're definitely in the danger zone of being inadmissible. So once you leave the country, then you would face an automatic bar and be inadmissible for 3 years. If you've overstayed over a year, that turns into a 10-year bar. How to fix that is going to depend on what you qualify for. Do you have relatives here that can help you to fix your status? Once you've overstayed your visa, it's very difficult to apply for an extension at that point. So in this case, it's very important for you to get a consultation to go through your full facts, go through the timelines, figure out what the best way is to approach your situation. If I haven't overstayed, can I still stay? So Stawil 91, if you can maintain your legal status for the entire process, then you can adjust status. So that is one of the ways that you can stay in the US and apply for your permanent residence. And I think this is through your father. But keep in mind that when you're on a visitor's visa, it's going to expire at some point during the process, because if you're being sponsored, you're over 21, you're being sponsored by a U.S. citizen or legal permanent resident spouse, or parent, then it's taking years. So it's taking 5 to 7 years for these processes to go through. And there's no way that you can maintain your B2 visa status, your legal status in the United States for that long. And so if you overstay, your situation will definitely get more complex, and you would not qualify for adjustment of status once you've overstayed. And at some point in the process, that's going to happen. Do I have to get vaccinated to get my marriage green card? So starting October 1st, yes, you will have to, because if you're getting your marriage green card, you're going to have to do your medical examination. And they are requiring that during the medical, you verify that you have been vaccinated, unless you do qualify for an exemption. So it's based on a religious exemption, and so they don't necessarily have a list of religions that they're going to excuse from the COVID vaccine. Now, to qualify, generally speaking, on a religious basis, you would have to show that the religion that you belong to have prohibited you or are against vaccinations, and usually in general. It's very hard to argue that your religion all of a sudden is against COVID vaccines now. So usually there's that religious exemption, and then if during the medical examination the doctor determines that you should not be getting this vaccine because it's inappropriate for you. For example, if you're under 12, you can't get the vaccine because it's not approved for children. So the doctor would provide an exemption in that case. If your health profile fits within a category of individual that shouldn't be getting the vaccine, or it's against guidelines for that individual to get the vaccine, the doctor would definitely provide that exemption. So at the medical examination, if you're not going to get it before, you should definitely speak to your doctor about those kinds of options, and they will advise you based on what they're finding during the exam. Also, if the vaccination is not widely available, that might also be an exemption there. Does nationality of immigrant spouse matter in terms of bias or discrimination? So no, it should not. Can you travel internationally with an info pass? So it depends. So if you receive some sort of at your info pass appointment, but no, you cannot travel with just an info pass. You have to have some sort of travel document to be able to travel outside of the US. Is it better to apply for a spouse visa after 2 years marriage, or just apply right away after marriage? So I would say, why wait? Why wait? If you guys want to be together, then go forward with your application. Get your green card. I think it really depends on what works for you, right? There's nothing that says you can't apply for permanent residence. There are no timelines that you have to abide by. You want to make sure that you are careful. And so if there is something that you are concerned about in your particular situation, then definitely schedule a consultation, and then we can talk about your options. However, generally speaking, why wait? If you are married for less than 2 years at the time that you get approved for your permanent residence, you'll get a 2-year green card. But as long as your marriage is bona fide and all is well, then you can just renew that after a year and 9 months to a 10-year green card. And yes, that process is like going through the green card process all over again. But I would not worry. If you are in a bona fide marriage, then there's nothing to worry about when you're going through the process. If we are married 8 months, should I wait until 1 year to apply for the green card? Not necessarily, Juju B876, but that's where a consultation is very important. If there's something that you're concerned about, and that's the reason why you're raising this 1 year issue, that's where the consultation will allow me to personally advise you, because generally speaking, there's no rule that I have had clients that have been married for less than that time and still successfully completed the green card process. So there's nothing that says you can't do that. However, in certain situations, the time that has passed does matter, and that's where you need to schedule a consultation to talk about that. What if they give you a day to come back on the day that is a problem? So if that is a travel document that you're talking about, Eureka, yes, that could be a problem. You definitely want to schedule a consultation and let's talk about what happened. How many times for the month do interview dates come out by the embassy? I'm from Guyana, so I don't have that information on hand. Saw a vacancy for a school bus driver in the U.S. How should I go about applying? So I am not usually involved in the process of applying for employment in the U.S. That is definitely up to you. However, when the employer wants to sponsor, at the point that they're ready to sponsor their employee, or you're ready to go ahead with the immigration side of the process, that's where I would come in. Should I apply for a work visa first, or the school they have to accept me? So when you're talking about a school, definitely you're gonna have to go and apply for a student visa. But keep in mind that the ability to work, you would not get a work visa off of a student visa. So you Pretty Boss Accessories, that's where you have to schedule the consultation to determine what option works for you, because it's either you're going for the student visa or you're going for an employment-based visa, but it's not usually a situation where you can get into a school and then apply for a work permit. It doesn't work exactly like that. They give me 15 to come back, and I came on the day. Okay, so Eureka, that's where if you want legal advice, schedule a consultation, because I have to figure out what's going on in your situation in order to advise you. Hello there, Priyankas. My receipt number and online access code has expired and I need to reset. So in the case that you are trying to access your online account, you will need to contact the USCIS technical support and ask them for help on your technical issue. So thanks everyone for your questions. Now this conversation does not have to end here. I am going over to Instagram, where I'm going to continue a live there. I do a pre-scheduled live there. So we can continue this conversation just as we are now. You can just go to the link in my bio. You can click the Instagram button and it's going to take you to my Instagram page. My Instagram handle is @TheImmigrationAttorney. So The Immigration Attorney, same as here. Riz, you are welcome. So if you can't make it to Instagram, guess what? I'll be back tomorrow at 9 p.m. Eastern time. So just mark that time and come right back on and just start throwing those questions at me, because that is why I'm here. I'm here to answer your immigration related questions. Now, if you know for sure that you are definitely going to need legal advice, go ahead and schedule the consultation. There is a scheduling coordinator who is available up until 11 p.m. tonight and tomorrow and the day after. So Monday to Friday, it's 9:30 a.m. to 11 p.m. There are scheduling coordinators who answer the call. They put you on my schedule and confirm your appointment. I did see Starwill91 ask what's the cost for the consultation. It is $150 for up to an hour. So it is worth it though. That's what I like to follow the cost with. You walk out of that consultation knowing exactly what you need to do, how to approach your situation. You avoid devastating mistakes that can turn into expensive mistakes. And I like to point this out, that for $150, you get that legal advice from an immigration attorney. And it can save you in the long run, because if you go ahead, I've seen so many times where individuals jump into a process without fully knowing the implications of it, and they end up paying more money. They end up it ends up costing them personally as well, because there are long-term immigration consequences that can happen as well. So it is worth it to schedule the consultation and empower yourself with the information you need to understand your process, understand what you need to do, and get the legal assistance you need to make your immigration benefit possible for you, to be able to change your life and move forward with your situation. So I hope to see you on Instagram right now in a minute. But if you can't make it, I hope to see you tomorrow at 9 p.m. Eastern Time. Have a good night, everyone, and I'll see you in a minute on Instagram.